Welcome. This is the ninth meeting of the Rhode Island Ethics Commission. You would have a quorum present. The first item on the agenda is a motion to approve the minutes of the open session held on May 20th, 2025. Is there a motion?
So moved.
Motion by Commissioner Rapidu, second by Commissioner Browner. Roll call vote, Commissioner Susie.
Aye.
Commissioner Strauss is absent. Commissioner Browner.
Aye.
Commissioner Callahan.
Aye.
Commissioner Santorini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rapidu.
Aye.
Commissioner Ritchie. Aye. Chair votes aye. The next item on the agenda is the director's report.
Good morning.
Board.
So, start just discussing complaints and investigations. We have 4 complaints pending right now. Kind of go down the list where we are on the matter regarding James Thorson. We have a status conference in open session today to talk about where we are with the discovery that the commission granted previously. In the Heidi Weston Rogers complaint, that investigation is completed. Had a probable cause hearing, and the attorneys are still in communication to talk about the resolution of that case and maybe setting an adjudication date. Jason Licciardi is a matter that's still under investigation, so that's 3 probable cause still being investigated. And as that is also the case with the complaint against Jonathan Pascal. So 2 complaints under active investigation. Moving on to advisory opinions, we have 7 advisory opinions pending. 2 are on today's agenda today. I know 2 seems kind of light, but the remaining ones, 3 of them came in at the end of last week, and the other ones were just getting more information, still in the information gathering stage. Had 7 APRA requests since the last meeting. We've already today had several more, but of the ones that came in before today, they were all completed within 1 business day, as the Ethics Commission always strives to do, rather than waiting for the allowed 10 days. Of those, 5 related to advisory opinions, 1 related to a complaint, and 1 related to financial disclosure statements. Moving on, just without taking too long, just a update on the 2024 financial disclosure season, which, as you know, ended at the end of April. We're really in the home stretch here on 2024 non-filers. We are down to 41 people out of about 4,200 that have not filed yet. On top of that, 22 people have extensions of time, and that extension is going to expire this month, June 24th, I believe. And so we normally see the extension people all file right there on the deadline date. So that puts
Jason, the 22 you mentioned, are they part of the 41?
no,
Okay.
no, that's on top of the 41. Historically, extension filers file. If you go to the trouble to ask for an extension, you file by the extension date. So we're not normally seeing them not file and become an entry to non-filer status. So with only 41 left, that puts us right at 99% file, which is just great. Again, it's the best we've ever done, ever. And it's finally gotten us, after many years of working hard, to this situation where we always wanted to be with financial disclosure, which is where we can now say with confidence that you will either file your financial disclosure statement or you will have a complaint filed against you. And in some years past, there were so many non-filers, it wasn't feasible for us to file 150 complaints or however many. But shortly after the extension deadline ends, we'll see who's left and we'll initiate complaints against everyone who's still on that. And by that time, there will probably only be up to 1. And maybe even less. So that's, and just to give, in case you're, I mean, I'm interested in financial disclosure. For some reason, I love the numbers and I always have. So in case you're interested in what the breakdown is of these 41 people, it's 53% municipal officials, 27% charter school board members, 16% state boards and commissions and decision makers, and 4% fire district. Then moving on just to some general office administration, our next meeting is July 1st. Maybe updates on that. Then finally, I just want to announce that we did just receive our annual new intern slash fellow from University of Rhode Island, which every year we have a partnership with the John Hazen White School of Public Policy over there in their political science department, and go through a competitive selection process for someone to come work at the Ethics Commission, not just be an intern, but actually come work with us for the summer. And we just this week, Danny Barbosa from URI started. There's Danny right there. Danny is a dual major in political science and history, and involved in student senate at URI, and comes to us from another internship at Senator Whitehouse's. So we're really happy to have him here this summer. He's going to help us out a lot. The last thing on the director's report, just briefly, is the legislative update. Just need to give you one update on one of the bills that I talked about previously. There had been two bills pending that impacted the Ethics Commission. One had been in the Senate, and that had to do with the gift rule. And then there was the one in the House 6166, which would define sexual harassment and would make it a violation, a civil violation, to engage in sexual harassment by members of the legislature, employees of the legislature, including interns and pages, and lobbyists. And the reason it interested the Ethics Commission was that it named the Ethics Commission as the investigative and adjudicative body for these sexual harassment investigations. And we were just keeping an eye on it. And the hearing had been postponed, and ultimately the hearing got called for last week at a moment's notice. And I spoke with the bill's sponsor, Representative Tansey, and she requested that someone from the Ethics Commission come to be available to answer questions and to provide some testimony. So I consulted with our chair, and I went to the hearing. And it turns out that the reason the Ethics Commission was identified, rather than some other body like the Commission for Human Rights, was an impression that some of the people that were helping the sponsors draft the language, they have some nonprofits that they're working with. There was a belief that only the Ethics Commission has the ability to investigate members of the General Assembly due to constitutional legislative immunity issues, particularly the speech and debate clause, which is the same clause that was at issue in the Irons case, if you remember, when former Senate President Bill Irons, it was determined that we couldn't investigate until the 2016 amendment to the Rhode Island Constitution that clarified that the Ethics Commission can, in fact, investigate members of the General Assembly, notwithstanding the speech and debate clause. Sorry to get too far into it. The point is, there was that belief that only the Ethics Commission is the only agency that could handle this. I happen to strongly disagree with that theory. While we're the only agency that can investigate members of the General Assembly for ethics violations, conceivably, things like bribery or sexual harassment, things that are illegal, notwithstanding exercising your judicial authority, are not protected by speech and debate immunity. And I'm pretty clear about that from the research that I've done over the years in legislative immunity. So I also happen to know that the Commission for Human Rights already has sexual discrimination and sexual harassment jurisdiction, and that they would seem to be the natural place to go to with this. And that was pretty much my testimony. Although I will say that the testimony was very moving at this hearing, and you're welcome to watch it on Capitol Television. There does, in fact, seem to be a kind of a vacuum where people who may believe that they've been sexually harassed up there don't really feel that they have someplace to go to to bring those accusations. So I think it's an important bill. I'm just, again, I think they might be misinterpreting the legislative immunity issue. And if that weren't part of it, the natural place to investigate this is the people who already investigate these issues and are trained in it. And that is the Commission for Human Rights. So the bill's been held for further study. There is no Senate companion to this bill currently. And the sponsor even indicated that she used this year as kind of a fact-finding year and to gather information. And I have informed her and spoken with her that, the Ethics Commission is willing to stay engaged in the conversation. And then we'll see where it goes. So that's my report on that.
Just a quick word. I had a 13-hour drive home from Virginia on Sunday. So I watched the hearing and I just wanted to compliment you on how sensitively you handled Representative Tansey's concerns. And it's such an important topic that I personally believe needs to be discussed. But you did it with diplomacy and kindness to have to say, I don't think it's us. And it's a tough road to hoe. And I thought you did a remarkable job. And it always makes me proud to be part of the Ethics Commission. But I was particularly so when I saw that hearing.
Thanks, I appreciate that. I mean, I brought the comments that came from you when we had the last legislative update. So I'm just trying to translate the comments that you all did. You spoke about last. That's the director's report, unless you have any other questions.
Thank you. The next item on the agenda are advisory opinions. Is there some, please? The first item is Valerie Lawson with Nicole Benjamin. Welcome, President Lawson.
Thank you.
Ms. Benjamin.
Good morning, Commissioners. This draft advisory opinion is under tab A in your binders. The petitioner was recently elected senator by her fellow Senate members. In her private capacity, she is the president of the National Education Association of Rhode Island, or NERI. This is a private nonprofit labor organization. She's here today to seek guidance from the Ethics Commission regarding whether holding both positions simultaneously create a conflict of interest under the code per se. The petitioner has continuously served as a member of the Rhode Island Senate since 2019. During that time, she served in various positions, including as the Senate Majority Whip, later as the Senate Majority Leader, and now the Senate President. As Senate President, she presides over all Senate sessions. She also establishes the daily consent calendar of bills and resolutions, and she does so in conjunction with the majority and minority leaders. As Senate President, she also appoints all employees, members of commissions, and other public bodies of which the Senate President is by law or resolution authorized to appoint. She also appoints the Senate Majority Whip and all other officers and employees of the Democratic majority in the Senate. The petitioner was formerly employed for 32 years as a teacher by the East Providence School Department. The petitioner has held her full-time lead position since January of 2023. She represents that NERI's primary purpose is to provide collective bargaining representation, grievance and arbitration representation, and professional development opportunities for its members. NERI consists of diverse membership, numbering approximately 11 to 12,000 people. NERI members include public and private sector employees organized in approximately 75 local bargaining units. Identification of NERI's various members are at the top of page 2 of the draft. The petitioner explains that NERI engages internal and outside lobbyists, and that although NERI lobbyists participate in each legislative year, their involvement is very issue dependent. The petitioner acknowledges that her duties as Senate President and her ability to participate in particular matter in light of her position with NERI is subject to a case-by-case evaluation. She notes that she is prepared to recuse from matters directly financially impacting herself, her business associates, or her employer, unless the class exception will apply. The petitioner represents that in the past, while serving in various Senate capacities, she has recused in circumstances where her business associates have appeared to present or testify before a committee on which she has served. The petitioner, however, anticipates that her recusal will be less frequent now as a Senate President because she is not an active member of any of the committees. I have listed the pertinent provisions of the Code of Ethics on pages 2 and 3 of the draft. The Ethics Commission has previously opined that those provisions of the Code of Ethics apply equally to members and to officers of public bodies. Consistent with the Commission's advice and prior advisory opinions, it is the opinion of the staff that the instant petitioner is not prohibited by the Code of Ethics from continuing to serve in or move up through the Senate leadership hierarchy, including serving as the Senate President. However, as the petitioner correctly acknowledges, the Code of Ethics does regulate the manner and extent of the performance of her Senate duties. Therefore, the petitioner is cautioned that she will generally be required to recuse from taking any official actions, including discussions and voting, on any matter that is likely to result in direct financial impact, whether positive or negative, to her, any person within her family, her business associate, or her employer, unless specific circumstances justify the application of the class exception. Notably, this petitioner just recently in 2024 requested an advisory opinion and guidance from the Commission on the application of the class exception relative to several pieces of legislation. That advisory opinion is 2024-17, and that it can provide general guidance as to the application of the class exception. However, today before the Commission, there are no specific pieces of legislation to which the Commission is asked to apply the class exception. Therefore, no specific guidance will be provided at this time. Now, going back to the requirements of the Code of Ethics, the petitioner would also be required to recuse herself from participation in discussions and voting on matters for which her business associate or employer appears to present evidence or arguments before the General Assembly or the Senate, unless one of the exceptions contained in Regulation 1.2.1b are present. I have listed those exceptions in footnote 2 on pages 4 and 5 of the draft. The petitioner would likewise be required to do the same if an authorized representative of her business associate or employer appears on their behalf to present evidence or arguments before the Senate or the General Assembly. The petitioner is also prohibited from representing herself or any other person before the General Assembly or the Senate. Recusal shall be pursuant section 3614(6) of the code. And lastly, the petitioner shall not use in any way her public office or any confidential information that she has received through her public office to obtain financial gain other than that provided by law, again for herself, a family member, business associate, or an employer. I'm happy to answer any questions you might have at this time.
Before we go there, Ms. Benjamin, I simply want to let you know that although in some contexts, council has to speak for the party only, in our context, we permit the party to speak as well.
Yes.
So I want to turn to you and President Lawson and ask whether you have any questions or comments concerning the proposed advisory opinion.
I do not.
Nor do I.
Does any commissioner have any questions of either Ms. Papa or the president and your council?
If I might, this is a follow-up from the executive director's report where he was talking about appearing before the legislative committee on the sexual harassment, and he was explaining the position of the commission. I noticed in the proposed opinion that there was not reference to the issues raised on page 4 of the petitioner's application, which the first paragraph, which expressed the reservation set forth by the Rhode Island Supreme Court. The Rhode Island Supreme Court apparently has stated in the cases cited that the Code of Ethics may not impinge upon either the legislative or executive powers. For this reason, the commission may not set standards that seriously impinge upon the executive or legislative branch's ability to perform the usual or ordinary duties for which it is elected, including the appointment of various officials to public office. The way I read that, it's almost talking about the separation of powers issue. We are a constitutional body, the Ethics Commission, but there are others. Has the points raised by the petitioner's counsel been addressed in greater specificity in earlier decisions of the commission? If I'm making myself clear.
I think the director will, may have a little bit more input on that. In 2016, we got our power back over the members of the General Assembly. So we are reviewing their actions with regards to the Code of Ethics. But I don't recall if in recent years anything in more specificity has been reviewed.
Can you just more specifically explain to me? So is it the position of the staff that what occurred in 2016 vitiated the line of cases cited by the petitioner's counsel? And if I'd like Ms. Benjamin's response too, please.
So I may not be completely clear on what the question is. I'm familiar with the cases that are cited in President Lawson's requesting advisory opinion. And I'm familiar with the Supreme Court's pronouncement that the Ethics Commission can't seriously impinge upon separation of powers principles. So for instance, the courts have said that when there was an opening in the Secretary of State's office, and when the Constitution allowed for the election of a replacement by grand committee, and the Ethics Commission sought to prohibit a member of the legislature from being elected to serve that interim position as Secretary of State, the courts said, no, that's not a constitutional provision. The election in the grand committee, the Ethics Commission can't adopt a rule that it turns the Ethics Commission into a kind of revolving constitutional convention, always amending other constitutional powers. But what we're doing today, but what the courts have also said in some of these cases and in others, which they've reviewed the Ethics Commission's authority, they've said that the Ethics Commission has some aspects of all three branches of power. So when we adjudicate cases, we have a little bit of the judicial power, some quasi-judicial power. And when we adopt the Code of Ethics, we have a little bit of legislative power. When we investigate, we have a little bit of executive power. And none of these things stop any of the other branches of government. None of these things seriously impinge upon the powers of the other branches of government, and so separation of powers principles are not offended. So I don't think anything in President Lawson's letter is indicating that it's her belief that the Ethics Commission doesn't have the authority.
I agree with that, but I was just trying to educate myself. As to, we've had a string of cases. Going back a period of time where the Rhode Island Supreme Court hasn't agreed with the Ethics Commission. And of course, we're duty bound to follow their directives. I'm just trying to get the perspective of whether the issue has been addressed in earlier decisions of the Ethics Commission. I understand that the president is not challenging any of the authority of the Ethics Commission, and I respect that she's so fully submitting herself to our jurisdiction. But I'm looking at it based on your earlier report to get an understanding of at least what the staff's perspective is.
And to answer your first question, I do believe that the 2016 amendment to both Article 3, Section 8, which is the Ethics Amendment, which clarified that we have jurisdiction over the General Assembly, and a simultaneous amendment to the Speech and Debate Clause, which is under the legislative powers, which amended the Speech and Debate Clause, which used to say, for any speech or debate in either house, no member shall be questioned in any other place, period. 2016, that was amended to say, for any speech and debate in either house, no member shall be questioned in any other place, comma, except before the Ethics Commission.
Has there been any decision from the Rhode Island Supreme Court or the Superior Court on that?
No.
Do you still wish to hear from Ms. Benjamin?
I would.
I'm happy to address that, and I think really the intent here is to make it clear that our understanding is that the code of ethics is what governs here. That's the code that is applicable in this forum, as opposed to some other construction of what a conflict might be. So the code of ethics is very clear that there is a conflict in certain specified circumstances. Those are also specified by statute. Whereas here, the point that we're making is that you can't look at this from the perspective of what is a conflict generally. You know, what somebody might think is a conflict is different than what might be defined as a conflict under our statute and under the code of ethics. So here, the point is simply to say that the code of ethics is what governs here. The definition of what a conflict is what applies here. So the suggestion that somebody might, based on a perception of bias or a perception that by holding a particular position in one's private life, that might create a conflict, really that's not the appropriate analysis. The appropriate analysis is to look at how conflict is defined in the code of ethics, which is what this body does all of the time. And that was the intention of this paragraph here, to make it clear that it is, our understanding of the construction of the provisions of the code of ethics that govern, as opposed to some general perception that somebody might have that by holding a position in one's private life, that creates necessarily a conflict for purposes of this forum.
All right, thank you. Thank you.
Any other commissioners have questions?
On page 2, where the staff has suggested petitioner, however, anticipates that her refusal will now be less frequent in the present Senate role given Senate President. She's not an active member of any committee. Is there any amplification or concern relative to the president's testimony before a committee? Is that inclusive of that paragraph?
So
Do you know what I mean?
it-
So she's, I don't mean specific, but so the position, so we're not the human, the position, right? Where we are addressing that she will not be a member of a committee. Is there a concern about testimony before a said committee that she has leadership.
So the code requires the petitioner to recuse from any matter that will have direct financial impact upon health of business associate or employer. So if she's required to recuse, that includes discussions, decision, and decision making. So there'll be, I would assume that she'll be recusing from any testimonies before those committees too on the matter.
But with the public, speaking at a public forum exception within the commission, wouldn't that apply?
If the petitioner is presiding over
No,
a hearing or.
whether, as I recall, and I seek the guidance of the more experienced commissioners, but and staff, but I thought that a public official could appear in a public testimony, to give public testimony, I defer to legal counsel, and with that,
Unless
address
they're a
Commissioner
party or
Cal.
participant to the matter there.
Well,
Unless, yes, you're correct, unless they are a party or a participant in the matter subject to the hearing.
so with that, with that applied to Commissioner Callahan's concern.
I believe if she gives, if there is a public comment that's allowed, a public comment session, and she provides her comments as part of that public comment.
Session, that would be an
That's,
exception.
that can be different than testifying for a committee.
Satisfied. Any other commissioner questions?
Yes, Mr. Richard, the staff. Has the staff researched what, if anything, other states have done or do regarding the situation? Or that is a position of someone with vast power, the president of the Senate has.
We have not researched, I personally haven't researched any other states. I'm basing the advisory opinion of the staff's recommendation solely on the Rhode Island Code of Ethics and the prior advisory opinions and guidance issued by the commission.
It can make the important to do so.
If the commissioners think that that's something might be helpful to us, but I can only base it on the code.
We're doing that now, when it comes to, level of fines, level of penalties, although we're not bound by, nevertheless seem to seek, information regarding what other states do in certain situations. But notwithstanding that, although I think that should be done, but notwithstanding that, has the staff taken into consideration, vast power that the Senate President holds? What I'm trying to say to you is this, could a mere recusal would not be sufficient? Her position is overreaching position. She is in a class of one. She's not a general member of the Senate anymore. She's the president of the Senate. And with that comes vast powers. Her silence speaks loudly. And members of the Senate recognize her position. It's a powerful position. So, and then also, there is some precedent in the staff. They have forgotten or not being aware of, that as her predecessor, late Senator Diamond Nigeria, faced with a similar situation, chose to step down from his powerful leading position. Was not to cause any conflicts. He felt as though his position as president of the Senate will do such. And he left his union job, being president of the Senate. So again, has the staff taken that into consideration?
I have taken it into consideration. The question before us today is whether her being elevated to the top of the hierarchy of the Senate leadership is per se a conflict of interest with the code. I based staff recommendation based on prior advisory opinions that say that the code applies equally to members and officers of public bodies. The fact that she may have now more powers than a regular Senate member may come into consideration under specific circumstances. As during the last meeting, we were discussing the class exception and what the implication of somebody's position might be, and whether or not it will be taken into consideration. So I believe that those powers may be more specifically addressed in specific circumstances that may come later on before the commission.
Well, except in this situation, the question or the issue of class exemption is not before us.
Correct.
So what is before us is the undeniable power that the president of the Senate or the speaker of the House has over its body. This is unique. The only precedent, if you will, is that of late Senator Ruggiero. So I'm concerned. And I'll ask Madam President. It's not in any way, shape, or form to impugn your character or your reputation, which I consider to be outstanding. What I know. But you agree with what Senator Ruggiero did? I'm asking you a question.
Commissioner Ritchie, we don't know the details that you're speaking of about former President Ruggiero. I don't know that she
I
does.
want to ask her that.
We
May
don't.
I ask her that, sir?
I'm not sure.
Oh, you're not sure?
I'm not sure.
Counsel, can I ask that question?
Well, this is not an investigatory
You
proceeding.
know, but I can ask her a question of her mindset.
I think it's kind of beyond the scope of what these advisory opinion hearings, it's not an investigatory proceeding at all. The advisory opinions that are presented to this commission are to be approved or not approved based on the facts as represented by the petitioner. It's not an investigatory proceeding at all. And I think we're starting to go down that road of turning it into
I have no
investigatory
intention of
proceeding.
doing it. You misinterpreted what I'm trying to determine here. All I'm trying to find out is what her opinion is, of what her predecessor did, and also what her opinion is as to the vast power she holds over the commission, over her body.
Well,
So that's not investigating.
I don't see that as a
To
material.
the end of
I
it,
don't-
over
I
the
don't
power,
ask-
over the power that she has over the commission, over the Senate.
Respectfully,
She doesn't have to say a word.
Respectfully,
She's the president of the Senate.
Respectfully, Commissioner, I do not believe that is before us. I also want to say two things which may be part of the response. One is your point about other states. We're stuck, I'll say that in the wrong way, but we're stuck with our statute and our regulations on this issue. What other states do in this context is really irrelevant to our situation. Secondly, on the fines, we asked them to find out about fines, so we would have an idea of the range of fines imposed by different states, not the basis for their fines. And on your,
That's my point.
on your last comment, we must accept the good faith of a recusal until a complaint is filed.
Well, I
So if
understand.
if the president is saying, for the record, which she has in her application, that she will appropriately recuse when matters come before her that involve her business associates, that she will recuse.
Exactly, and why not find out from her if she thinks her recusal is sufficient, given the vast power as the president of the Senate? That's all, a simple
She
question.
doesn't,
Well, I stand by that vote.
I'll ask Ms. Benjamin in order to give Commissioner Ritchie's, do you have any I don't see this as an issue probably before us, but I also don't want to close it off if you care to respond. Let me put it that way.
I'll say this, I mean, I think one thing that's important is that we have a part-time legislature, and I think our code of ethics recognizes that individuals do have private lives, and I don't think that that turns in any way on the position that someone holds. There's nothing in the code of ethics that pertains differently to someone, whether they are in a leadership role or not. The provisions of the code of ethics, including the recusal requirements, apply equally to everyone. And I think Attorney Papa is correct in pointing to the prior advisory opinions issued by this body, which very specifically say that it does not matter whether someone is holding a membership as a part of a body at large or in a leadership role, and specifically talks about the elevation of individuals from membership to leadership positions, and does not draw a distinction between those leadership positions and the manner in which the code of ethics applies to them, as applied to them as members at large.
Wouldn't you agree that the situations you just cited are completely different from the one before us today, in that the solicitor, for example, we're not talking about solicitor's son. They're talking about the solicitor's son's position. Here, we're talking about the job that the Senate president has, the income derived from that job, and the power of the presidency as it relates to matters that come before the General Assembly, the Senate, union matters, that is. Far different. The examples they cited have nothing to do. This is a unique situation. And again, this is in no way to impugn the character or the integrity of President Moss. No way in shape or form. I've not heard it, and you can understand that, and the commission understands it. I am just very concerned, legitimately concerned about the power that she has as president, and that what's before us today is unique. I'd like to see it, see what other states have done or do, and I'm not bound by it. I understand that. I said that clearly, not bound by it. And I think it really needs some further investigation. That's
Mr.
my statement.
Mr. Chairman. In listening to this, I'm reflecting on where I sit and where my other commissioners, brothers and sisters sit. We've been all appointed by the government. We've had no problem reviewing complaints against the person who's appointed us. You get down to an issue of character. Are you gonna call balls and strikes as you see them?
I should have not speaking to kind of,
Please, Commissioner, don't
but
interrupt.
I'm concerned for character.
Please don't interrupt. We let you speak. Let Commissioner Centarini speak, please.
You gotta call balls and strikes as you see them, according to what vests you with the authority to call the balls and strikes. I think, with all due respect, we're drifting away from the central issues in this matter. I say that with all due respect. And I apologize if I opened this up, but I had issues regarding the constitutional cases that were cited by the applicant, which I am not criticizing at all. That's what the Supreme Court says. I've been in positions where I've had to decide things when I don't agree with the Supreme Court. That's the game.
Yeah, I'll carry the baseball metaphor a little further, and I'll start this by saying I umpired 2 Little League games last night in the rain. Strike zone is a strike zone. Staff has given us a staff opinion based on the strike zone that we have here. State of Rhode Island has decided to have a part-time legislature. If the state of Rhode Island decides that the president of the Senate and the majority leader of the House and the Speaker of the House are to be fully compensated, and outside of that, well, that would be a different story. I think the staff has worked within the regulations that we have, and I think the advisory opinion that they're presenting us is consistent with our regulations.
Commissioner Ritchie, I'm gonna ask for a motion first. I will ask for discussion after the motion is before us, and I will open the floor back up. So is there a motion to approve and issue the advisory opinion as presented by the staff?
I'll move that.
Second.
Motion by Commissioner Rabidus, second by Commissioner Susie. Any further discussion?
Make a motion that the matter before the commission today be continued to give the staff an opportunity to investigate what other states do or have done in similar situations.
I don't believe a motion on top of a motion
Oh, yes, you can.
is permitted.
Well, discussion. You can take
That's a
vote. You can take
motion you're
vote. You can take a vote.
Is
on
there
my
a
motion.
second for the motion?
That's all you have to do. Now you
I
can
see no
proceed.
second.
Now you can proceed.
Any other discussion? A roll call vote. Commissioner Susie.
Aye.
Commissioner Browner.
Aye.
Commissioner Callahan. Aye. Commissioner Santorini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rabidou.
Aye.
Commissioner Ritchie.
No.
The chair votes aye. Thank you, President.
Thank you.
Thank you.
Thank you all.
The next item on the agenda is Lawrence Mandel. Oh. Yeah, I saw that. It's not me.
Yeah.
No, I know.
Morning.
Morning.
The tab for this petitioner is letter B in your binders. Welcome, Mr. Mandel. I had to tell myself it's not Barbara as in Mandel, it's Mandel as in Handel, Messiah. So that's how I remember it.
My apologies. I know Mark Mandel.
There we go. Okay.
As long as it's spelled correctly on the check.
No checks here.
No check.
The petitioner is a former member of the North Kingstown Town Council. He served in that capacity from December of 2022 through December of 2024. He would now like to apply to become a member of the North Kingstown Planning Commission. That appointment is made by the Town Council. Members of the Planning Commission receive no stipend or other remuneration for their service on the Planning Commission. Mr. Mandel has asked for this advisory opinion because he left the Town Council less than 1 year ago. Regulation 1.5.4 of the Code of Ethics prohibits a public official from seeking or accepting employment with any municipal agency in the municipality in which that official serves while serving in the office and for a period of 1 year after leaving office. Also, under Regulation 1.5.1, no elected or appointed official may accept any appointment that requires approval by the body of which he was a member to any position which carries with it any financial benefit or remuneration until the expiration of 1 year after the termination of his membership on that body. Notably, the receipt of compensation is a necessary element in the application of both regulations 1.5.4 and 1.5.1. Here, petitioner represents that there is no stipend or other remuneration associated with service as a member of the Planning Commission. Accordingly, it is the opinion of staff that the Code of Ethics does not prohibit this petitioner from applying for and, if offered, from accepting appointment to the North Kingstown Planning Commission. I'm happy to answer any questions or defer to our petitioner as appropriate.
Mr. Mandel, do you have any questions or comments concerning the advisory opinion?
I'd just like to say how important the work that you all do, and I appreciate everything that you do regarding this. I think ethics is incredibly important. I spent a career in the federal government as a U.S. diplomat and was very cognizant of my role representing and setting an example for the United States of America overseas. And I respect very much what you all do and appreciate that.
Any questions or comments from the commissioners? There being none, is there a motion to approve and issue the advisory opinion as presented by staff?
So moved.
Motion by Commissioner Ritchie, seconded by Commissioner Callahan. Roll call vote. Commissioner Susie,
Aye.
Commissioner Browner,
Aye.
Commissioner Callahan.
Aye.
Commissioner Centarini.
Aye.
Commissioner Peterson,
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
And the chair votes aye. Thank you, sir.
Thank you.
We appreciate your comment. And your service.
Yeah.
The next item on the agenda is the status conference in Ray James E. Thorson, complaint number 2023-7. Rules Council President Bristow. Kelly, welcome.
Thank you.
In this context, Mr. Bramett is representing the prosecution, not our executive director. I want to make that clear. So he is participating in a status conference regarding the status of the investigation relating to Mr. Thorson. And I think under the circumstances, since you're the prosecutor, I'll hear from you first.
Thank you. So I don't have a lot to say for a change, and I will just say that I did meet with counsel for the respondent this morning prior to the hearing. I understand that the deposition may have been scheduled, and I'm gonna leave it to them to advise you as to the progress.
Thank you.
Yeah, Attorney Kevin Bristow.
Waterville.
With Fred Kelly, the full council. Good morning, everyone. Yeah, this has been a much longer road than we anticipated. And certainly I assume the commission member's frustration, but also my client's frustration. He wants to get this resolved and get it done. We, since we were last year, since we got permission, and authorization to issue the deposition subpoenas as well as the production subpoenas, we've retained counsel in Pennsylvania. They have gone through a somewhat convoluted process in the Court of Common Pleas in the city of Philadelphia to get this brought to a head, despite the fact that Pennsylvania adopted that uniform statute relating to providing full faith and credit to out-of-state subpoenas. Judge before whom counsel was appearing required the Superior Court here in Rhode Island to authenticate, not to authenticate, but to give their approval and to issue an order, also allowing for the discovery to take place. That's going forward. We actually thought we might be able to eliminate the need to take the depositions by having the two individuals down in Pennsylvania, Mr. Scantapiccio, Mr. Abbott, sign affidavits as to what we thought were material facts that we would need to have sworn statements to relating to anything that we could anticipate testifying to before you folks at a hearing. And that has been the most frustrating process because we thought we had that done. There's a lot of, without getting it any deeper in the weeds than I am, a lot of back and forth with emails, us urging them to get counsel. They don't have counsel. They were speaking to their company's representative, and then they may have retained counsel at this point. I don't know, but we have the deposition scheduled as of like yesterday afternoon for a week from this Friday, which is June 20th, and that, that's subject to Mr. Graham's availability, and everybody recognizes that. And the only thing I would say as it relates to this, I mean, we have repeatedly been assured, this is via electronic communications, emails, that in a reasonable time before these depositions are taken, the request for production will be satisfied, and that there's no objection to the request for production that the commission authorized. We don't have it yet. But having said that, I fully expect, based on all of the correspondence, they would do that. I just need to advise you of that because it's possible that could result in this getting pushed back even a little bit further, if they're not doing that. But that's all been filed and authorized by the court down in Philadelphia, and we fully expect to go forward. So thank you for your patience, connection with this. And actually, you're asking us to come in and advise you as to what's going on, to bump this forward a little bit. And I don't want to say give ultimatums, but basically say, look, it's time, you have to make a decision, we're either gonna, sign something that we could use a little bit deposition, or come it down, you're gonna have to, make time, because it's what's required to do. Okay, any questions? Yeah.
I believe that was our purpose.
Yeah.
Bring you here and hope that we could get a degree of the movement on this, because all we had been hearing was, we're trying to schedule a deposition. Secondly, I will talk to the executive director, but am I to understand that in order to authenticate an a subpoena that was authorized to be issued by this body, you have to go to the Superior Court?
That's correct. All right. And yeah, I've sort of filled Mr. Graham in as we've gone along. I probably haven't been the best communicator, but I've certainly been copied on some things that we've done that were appropriate. I thought, yes.
Let me carefully restate that. I will want to speak to Mr. Graham as executive director about the concept that we have to, that subpoenas authorized to be issued by this body have to go to the Superior Court. It will not be specific to your case at all.
No, thank you. And this may have been a nuance of the particular judge who was before whom the matter was presented in the Pennsylvania court. But that's what they required. So that's what we did. And try and move the ball forward. Okay.
Anyone have any questions? Any commissioner have any questions, comments? Mr. Graham, anything to respond?
Thank you.
I don't have anything to add other than I'm hearing the representations that is subject to my availability, which is a week away, which is kind of close, and we don't have the production yet. But, we've all been dealing in good faith, so there will be.
Appreciate that last comment that everybody's acting in good faith.
Yes.
Any other questions, comments? Thank you, gentlemen. We appreciate you coming here today.
Thank you.
Our next item is a discussion of rulemaking timeline. That's okay, Graham.
This is, it should be pretty brief. Just want to let you know where we are in the rulemaking process from the last meeting. As you recall, in the last meeting, the commission voted to initiate the formal rulemaking process on both of the rulemaking issues. The 41 has to do with amending the interested person definition to always include lobbyists who are lobbying people. And the other was to consider raising the gift limit from 25 to 50 times. Or what other number comes through in as the commission continues to consider it. So that vote happened. The next step, which was to go through the incredibly time-consuming process of working through the Secretary of State's online regulations database to get the process actually going. There's a lot of back and forth between us and the Secretary of State's office to get the filings perfect, and we've done that. So all that needs to happen now to move to the next level is to pick the date that we want to have the public hearing on this matter. I could have picked it myself, but it really I didn't need to, and I thought it would be better to get a little bit of input from you as to when you want to have this hearing. We need to send out notice to anyone who might be interested in providing comment, and we need to give 30 days for that comment to come in. Just so you know, we're pretty good at providing notice, and among the ways that we're going to provide notice is we'll be sending written notices over to the General Assembly, to the House and Senate for distribution to all of their members, letting them know what we're doing and soliciting either written or oral comment at the public meeting. We will send the same type of notice to all 39 cities and towns, asking for distribution to their councils and other officials, and posting if possible and appropriate in the town halls, soliciting the same thing. We will be utilizing, we maintain a list of people and groups that are interested in what we do. And we send them everything that we send out. So things like our agendas, notices of potential rulemaking, things like that go to this distribution list. And the kind of people that are on it are Cause, the entire press corps, hello everyone, or they're still here. And other good government groups, Legal Women Voters, ACLU, among others, and legal counsel for a lot of state boards and commissions and public officials. As a final thing, what I think we'll do, I'm fairly certain that we will utilize this last resource, although we use it very sparingly. We have the email address of every person who files a financial disclosure form electronically. And conceivably, these people may have an interest in the gift regulation. And so we have in the past sent one email notifying those people that there's a matter pending before the Ethics Commission concerning the gift regulation, and here's what it is. And if you'd like to make a comment, please feel free to do so. The reason I'm hesitant to utilize that too often is, you know, people are giving us that email and asking us, please don't, not expecting us to spam them with, we use it for reminders. It's financial disclosure time. Your form is late, will you please file it? But I think it's appropriate, once a year to utilize it for a rulemaking type of notice, and we'll probably utilize that also. Then we will, all of the electronic written comment will come in. We will make that available to you prior to the meeting, to the public meeting. We will also make it available to the public. So we'll put it up where the public can look at all the written comment that comes in. And then on the day of the public meeting, we will invite people to come up to the podium and take 5 minutes apiece or however much time we need to give them, to talk about it. I know it seems like, boy, that's going to be a crowded meeting, but history tells me that, it probably won't be standing room only. We'll have a full room, but we can handle it. And it'll be the usual people that come in to talk about such things. So that's what we have to do. We need at least 30 days to let it sit once we post everything. So we need a little longer than 30 days. The meetings that are coming up, we have a few less meetings in the summer. We have one on July 29th, which we could do. We have one on August 19th, which sounds a little better to me, honestly, to make sure that everything comes in. We have one on September 9th, which would also work. But really, probably we should set it for one of those three dates. Summer, people are away, especially in July. I'm always concerned about scheduling things in July. August, school's back in session, things are coming back. I think that might be a good time to do it. So I'll just throw those dates again. We've got July 29th, August 19th, and September 9th as possible dates to hold up. It will be a regular commission meeting with a small agenda, and then mostly dedicated to public comment.
That was gonna be exactly my question. It will be a regular meeting with that as an agenda item. And on your notice issue, will you also be giving notice to all current registered lobbyists?
So that is a great question. I think the answer is yes, we will reach out to the Secretary of State's office and ask them for assistance in contacting the 2025 registered lobbyists.
Mr. Chairman,
Senator.
as you had earlier stated, this has been the subject of extensive discussions before the commission already. Also, what I thought that those discussions also expanded through the initiation with Common Cause to address nonprofits. And that, in my judgment, is a substantial clarification, potentially, that subject matter of the existing rules and regulations, nonprofits. Every time I hear a summary, it always drifts back solely to lobbyists. I think if we're not clear in our public notice, we are not meeting our obligations of reflecting the lengthy discussions of this commission.
I'm confident that staff, as they prepare such a notice, will take that into account. I have confidence in the staff in their preparation of such notices. So I think it's a good point to make, and I think your point is, I noticed Mr. Graham was taking down notes, so I'm confident that he will prepare such a notice to the extent there's any concern that it's expressed correctly. I'm authorizing anybody to contact Commissioner Santorini to go through it with you. Make sure it covers what you think it should cover.
Thank you.
Any other questions or comments?
Just one, I won't be here on August 19th, so if you set it on August 19th, that is my vacation.
I was gonna suggest September.
I personally believe September 9th of these dates is the appropriate day.
Yeah.
I don't think people are, despite what we think, I don't think people are around in August either. And though we're not in France where people would not be. around. So is there a motion to have the public hearing on the rulemaking process on September 9th, 2025 at our regular meeting?
So moved.
Second, motion by Commissioner by Commissioner Santorini, seconded by Commissioner Callahan. Roll call vote, Commissioner Susie,
Aye.
Commissioner Browner,
Aye.
Commissioner Callahan. Aye. Commissioner Santorini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. Thank you.
Thank you.
And I will. The next item on the agenda is a motion to go into executive session to wit. A motion to approve minutes of the executive session held on May 2025. May 2025. Pursuant to Rhode Island General Laws 42-46-5A, 2 and 4. And the annual discussion and review, legal counsel's contract pursuant to RI Gen Law section 42-46-5A1. And then a motion to return to open session. Is there a motion? Did we vote already on this? No. Is there a motion to go into executive session?
So,
By Commissioner Susie, a second. Second by Commissioner Browner. Roll call vote, Commissioner Susie.
aye.
Commissioner Browner. Aye. Commissioner Callahan. Aye. Commissioner Santorini.
Aye.
Commissioner Peterson.
Aye.
Commissioner Rabideau.
Aye.
Commissioner Ritchie.
Aye.
The chair votes aye. We will now go into executive session.